Funding for Frontline is provided by this station and other public television stations nationwide, and by the Corporation for Public Broadcasting.
Tonight on Frontline, the first television cameras ever inside a jury.
The man is guilty. Guilty is sin.
I don't care what the law says. Has justice been done?
12 ordinary people decide the fate of one man. The real-life drama of deliberations in a criminal trial.
The final decision is up to you, and more important, you have the power, despite all the technical legality, to find Leroy Reed not guilty.
Tonight, inside the jury room.
From the network of public television stations, a presentation of KCTS Seattle, WNET New York, WPBT Miami, WTVS Detroit, and WGBH Boston. This is Frontline with Judy Woodruff.
Good evening. Last year, for the first time ever on television, cameras were allowed into the jury room to witness a jury's deliberation. Tonight, we will rebroadcast our program about that unprecedented access. It was the result of a 3.5-year-long effort by Frontline producers Steve Hertzberg and Al Levin to gain access to a jury in order to learn about the process, the psychology, and the group dynamics of this most fundamental part of our legal system. First, they had to win the cooperation of a judge before they could even begin to try to find a case. Then, not only did they have to find a case where the prosecution, the defense, and the jurors would all agree to participate, but also find one in which the principles of law and justice, and not questions of fact, would be debated. Tonight, in the case of the state of Wisconsin versus Leroy Reed, you get to watch a dozen strangers become a jury, discover their power, and debate its use. Then you yourself may reach a surprising verdict on what it means to be a juror. Our program is called Inside the Jury Room. It is produced by Al Levin and Steve Hertzberg.
This is going to be a criminal trial. The state has accused the defendant Leroy Reed of violating the criminal law by being a convicted felon in the possession of a firearm. The state has...
This jury of 7 men and 5 women will decide the fate of an ex-convict who is accused of illegally owning a gun.
It'll thus be the task of this jury to decide whether the state has proven him guilty beyond a reasonable doubt.
Leroy Reed, 42, had a clean record since his release from prison 9 years ago. Then he got the notion he could become a private detective, and he went out and bought a gun.
I was looking at TV to get ideas about being an investigator, especially like this one person that comes on TV, this equalizer, you know. He comes on TV to help people out. More or less, job opportunity. Well, I'm anxious to get into job opportunity as a investigator, you know.
Reed was prosecuted by the Milwaukee District Attorney's Office, which is cracking down on gun control violations. DA Mike McCann.
I feel strongly about firearms. We have a policy directing assistant district attorneys to act aggressively in firearms cases. For that reason, we take this case seriously and every other firearms case very seriously. I just completed a month and a half ago a firearm violation where 2 officers were slain. The individual whom I prosecuted personally for it was illegally carrying a .22 firearm very similar to the one in this case. When the officer went to pat him down, he pulled out that firearm and shot to death 2 City of Milwaukee police officers.
The gun possession charge Reed faced was serious, and by exercising his right to a jury trial, he put his case in the hands of 12 everyday citizens. This jury, and all juries in criminal cases, stand as a buffer between the accused and the power of the state.
Please rise.
Once inside the jury room, the panel is on its own. They have been told only to follow the judge's instructions and to reach a unanimous verdict. Before starting their deliberations, they pick a foreman, a task they perform quickly and casually.
Let's choose a foreperson before we do any reading or whatever.
You're right. Unless somebody else wants it, you're it.
I don't care one way or another. It doesn't matter. All the foreperson does is puts his name in a document.
During the two-day trial, the jurors were not allowed to discuss the evidence with each other. Now, for the first time, they are able to talk about a case that had a very unusual beginning. In his opening statement to the jury, Reed's lawyer, public defender Charles Blaha, made a startling admission that Reed had indeed broken the law.
First thing, I'll tell you right now, right off the top, right before the first witness, Leroy Reed's a convicted felon. And on December 7th of last year, 11 months ago, he bought a gun. I'll tell you that right off the top. There's going to be no dispute about that. The second thing I'll tell you, he ought to be acquitted anyway, because he never should have been charged in the first place.
The possession charge against Reed came to light only because he himself produced the incriminating evidence. He had been hanging around the courthouse when a detective asked him for identification.
He produced a sales slip from Spheris Sporting Goods, which had his name on there as Leroy Reed.
Inexplicably, Reed handed over the bill of sale for the gun he had bought. He was turned over to the sheriff's office.
He told me that he needed the gun because he was taking some kind of a correspondence course as a private investigator, and he needed the gun to go along with the badge which he had on his person at the time I was talking to him.
When it was learned that Reed had a criminal record, he was told to go home and bring in the gun.
Mr. Reed came into my office and he stated that he had a gun that he wanted to turn over to the Sheriff's Department Detective Bureau. And I told him, all right, I'll take you up to the Sheriff's Department and we'll turn it over.
When Reed turned in the gun, he was immediately arrested and held in jail.
You solemnly swear that the testimony that you're about to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name, spell your last
The defense strategy was simple. His lawyer put Reed on the stand to show that in trying to find work, he had signed up for a mail-order detective course that he'd seen advertised in a magazine, and then he bought the gun. The defense attorney wanted the jury to see Reed as a well-intentioned man of limited ability.
Did you have to fill out a form when you bought the gun?
Yes,
What kind of form?
just an everyday form.
You see where it says date of birth?
Yeah,
You put 3.
yeah, I forgot to put the other.
Now, why did you put 3 under your date of birth?
I forgot to fill in the rest of it.
I'd like you, if you could, to take a look at this part of the form right here, 8B. Okay?
Okay,
See it there?
right.
Can you read me the first sentence in that, please?
But my reading is kind of difficult.
Well, go ahead. Give it a try.
I would have trouble.
That's all right.
Yonder mind.
Would you like some water?
No, my mind is not kind of heavy for reading.
All right, well.
Do you not want to read it?
No.
Okay.
The only other witness for the defense was a psychologist who said that Reed read at the 2nd grade level and that he had borderline intelligence.
Not quite within the retarded range, but substantially sub-average compared to the average person or the population as a whole.
At the end of the trial, both sides made their closing arguments. Assistant District Attorney Douglas Simpson argued that the jurors were obligated to uphold the law, whatever their sympathetic feelings for Leroy Reed.
There's an old saying in the law that ignorance of the law is not a defense. You indicated that none of you would speculate. You wouldn't be looking for some sympathetic reason or some conjured up reason to avoid your responsibility. That, in fact, the same law applies to everybody. If there's a statute or if there's a law, as the court gives it to you, you would apply that law to those facts no matter who the person was, whether they're short, tall, black, white, none of those kinds of things like race, weight, height. Mental ability would be a factor in your mind. A person who has possessed a firearm with knowledge that they possessed a firearm while being convicted of a felony has violated that statute. The person is guilty.
In his closing argument, Reed's lawyer urged the jury to refuse to follow the law.
The law is being misapplied to these facts. We've heard all about people getting off on technicalities. Situation where somebody's getting nailed on technicality. You have the power, despite all the technical legality, to find Leroy Reed not guilty. You're not violating the law by doing this. You are using the full power given to you by the Constitution and by the laws of the state of Wisconsin. You know why you have that power? Because you're not just 12 people of any sort. You are a jury. You've been sworn as a jury. You've heard the testimony and the evidence as a jury. And as a jury, you're an independent body of citizens from this community, and you speak with the voice of the community. You're independent of the judge. You're independent of the Milwaukee County District Attorney's Office. And nobody's guilty or not guilty until you say so.
Leroy Reed's fate is now in the hands of the jury. It is 2:00 in the afternoon as the deliberations begin. There are 3 elements of the law that must be satisfied if Reed is to be found guilty: that he was a felon, that he had a gun, and that he knew he had a gun.
If I make a suggestion, rather than, I know some juries, like Mr. Arvin mentioned, like to take a vote right off the bat, and I think if we do that, we'll probably end up discussing it anyhow, so let's just go around the table, discuss the case and your views, and after everybody's said their piece, we can take a vote on what we think, if that's agreeable to everybody.
Right now, I haven't made up my mind how I'm going to vote.
Okay. I feel that the defendant is guilty on all 3 accusations, technically. But I guess I feel that we should also take into consideration the fact that he does have a reading disability, as well as maybe some other disabilities. I'm not trying to play on your sympathies or anything, but it is something that I have to consider. And right now, I haven't determined whether I should deem the defendant guilty or innocent.
I feel that the plaintiff, the city, has found him guilty beyond a reasonable doubt to the three points that we are to discuss. The sympathetic point of view would be what his intent was or what he did not intend to do, and that's not for us to reason over. Ours are the 3 main points which we have to find beyond a reasonable doubt, and I feel that we did.
I really don't know which way to fall in this. It makes me extremely uneasy because I think it is a good law, and I think it's an important law. And there's no question but that this man is a felon, and that there's no question but that he purchased a firearm, and I'm not sure. This is something that I want to listen to other people, and I want to talk about and figure out as we go along.
I don't think any of us as citizens have to sit around and, regardless of who it is, and say the law is absolutely right because somebody made it for every individual. I think it's a tough position to be in, to say, I am a judge of the law, but I think that's what the jury system is for. It gives the people a chance in some instances to make some type of statement toward a specific law as applied to a specific case. And I think there are cases where it's not clear. And I think in this case, there's a lot of questions yet to be answered that we need to talk about.
I would be really hard-pressed to say that he was absolutely guilty. In light of all the information, I know all the evidence that has been turned in. His education level and his ability to even know the law, they might have even told him that if someone would have said, anyone who's a convicted felon cannot own a firearm, he still might not even understood that and still went ahead and purchased the firearm, not even understanding it. So I would have to lean more towards him not being guilty for those reasons.
I think that the evidence that the state presented to me was they were really showing me that there's a lot of reason for doubt here, that they probably had doubts themselves, because if this was a convicted felon and they knew he was a convicted felon, I don't think, if they are living to the letter of the law, that he had any right to ask this man to go home and bring in that weapon. And on those two judgments alone, I would not convict him.
Technically, the man is guilty. Guilty is sin. But I want to acquit Leroy because I don't think he was fully aware of the rules of parole. And secondarily, I don't think convicting him of this charge, this violation of law, will do the general public any good. But I feel that I'm shaky on this ground, and this is my fourth jury I've been on, and I'm willing to go with the majority in this instance because I feel I'm on shaky legal ground. That's all.
I agree that Mr. Reed is guilty based on the law. I believe that the law is good. I believe that the idea that there can be an exception made because of the particular defendant is what we have to deal with here. I personally would vote him an acquittal at this point.
Anybody that has about a second grade level reading, you wouldn't take a 7-year-old and ask them all these questions and expect them to understand all of them. Of course, the length of time he's lived, he knows. He's lived out in the world, and he knows more than an ordinary 7-year-old would in some areas. And it's also difficult to know just what he was thinking. The shame is that he's had to go along so long and not found some way where he could learn a little more. Maybe his capabilities wouldn't be like everybody else's, but the training hasn't been there. Something has been lacking. And we can't help that at this moment. But I'm not ready to give a real decision yet either.
We have a very philosophical argument on our hands in terms of, are we obligated as a jury to follow the letter of the law and find him guilty, or are we obligated as a jury to use our special level of conscience? As a defense lawyer said, otherwise it could be decided by a computer. And as I was thinking about this, I think it comes down to questions like, what is a jury and what is a jury for, and what is our purpose here? Because, as other people have said, and, I feel too that even given his mental abilities as being a handicap to him, according to the law as it's written, he meets the criteria. Do we rise above that somehow? Is there a place for us to then say, well, even though he meets the law, we cannot in good conscience find him guilty?
Our instructions were to decide whether, beyond a reasonable doubt, is he guilty of this crime. I think those three elements have been met, that yes, he is guilty of this crime. All the reasoning that I've heard around the table for each person's decision as to how they're leaning has been speculation, which we were all instructed not to use speculation. We have to use the testimony. And we can't use what we think his mental ability is, or what we think he understood, or what he didn't understand, or what we think he knows and what he doesn't know. We can't use that. We have to use what was brought out, the statements that were made in the courtroom and were allowed. I think the scope of a jury is to decide guilt and innocence, not to be the presiding judge. And so I think I have to follow the letter of the law.
After the first round of discussion, it is clear that the jury is struggling with one of the most difficult dilemmas in our legal system: how to reconcile the jury's obligation to follow the letter of the law with its power to exercise its own sense of right and wrong.
My feeling is that
Earlier during the trial, with the jury excused, the public defender asked Judge Ralph Adam Fine to instruct the jurors that they had the power to follow their conscience.
the only issue in this case is going to be whether the jury has the power to nullify the law. And I think a jury is going to wonder if they have that power. They don't hear it from the court. If they perhaps hear one counsel say, well, yes, you do have that power, they hear one counsel say, well, no, you don't have that power. And I think it's wrong to keep the jury in the dark about the power that they have under the law. I think they need to know.
The law in this state recognizes already that the jury may acquit for any reason or no reason whatsoever. However, to tell them they have that power would be, in my view, an invitation to anarchy, because it would permit juries to make that kind of decision in every case that was presented to them, and would, in effect, in my view, nullify not only the law of the particular case in which such an instruction was given, but nullify all laws.
Unaware of their power to disregard the law, some of the jurors argue that they are obligated to follow the judge's instructions.
I think there's entirely too much sympathy for the man, which is what is very hard to rule out. But we're not here to be sympathetic to him for what may or may not have happened. It's the 3 points of the law. Mr. Reed, to me, is not a violent person, and I'm sure he did not buy this gun with the intent of doing anything violent with it. He was swayed by a magazine article. That same person who has a slight, I don't want to call it a mental disorder, but a slight problem that he has, could read another article, and if he has a gun in his house, that could trigger him off into who knows what. That's why the law is there, why felons cannot own guns.
From what I've heard, I don't think we're giving this man a lot of sympathy. I do not think what we are expressing is sympathy at all. And one other comment, I am not a computer, and I will not accept everything that I'm told for just because I'm told that it is true. I can't do that as a thinking, breathing human being. And so other things come into play here for me. I'll tell you, to tell me that he's been convicted on these 3 counts, that's obvious. We're not arguing that. We all know that. Why? There's more to it than just that. There has to be more of a purpose for us than just to say, yes, he is. Bring in the computer.
What if Mr. Reed would have bought a gun and killed some innocent bystander somewhere along the line, and he'd be on this trial for murder? Then one would be so lenient to say that...
You said, let's not get into speculation.
Oh, yeah, right. I did. But you're using speculation to influence your decision.
Okay, I want to speak.
And I don't think we should. I think we should stick to the facts. That's why I brought that up, because I don't think that way. I think by the facts, and that's the way I think it should be.
I want to try to think by the facts, too. I mean, I'd like to be a good juror like everyone else. The law, as I recall, says you have to know that you have a gun. Now, you and I listen to that sentence, and we go right over that word, no. Stop. Do you remember when this was one of those things that made me wince. It's when the prosecutor...
When you brought the gun, you knew you had been convicted of a felony, right?
No.
I don't know if my question is confusing to you. Are you aware that we have all already agreed that you did know that?
When I first bought the gun, I didn't know anything about the law.
Okay. So what you're answering is that you're telling me you were ignorant of the law.
Right.
Okay. But you knew that you had been convicted of a crime?
No.
You did not know that?
No. I only know that when I got arrested.
You know Mr. Knox?
Right.
Why do you have to go see him?
He's my parole officer.
And the reason you have a parole officer is because you were convicted of a crime, right?
Right.
And you knew Mr. Knox in December of last year, right?
Right.
So you knew December of last year you were convicted of a crime.
Right.
So what's the problem today? Are you really nervous?
No.
Okay. Because when you talked to Mr. Butts, you told him, yeah, I was convicted of a crime. Isn't that what you told him?
No, yes, I was convicted of a crime. That's why I would go to the parole officer each month to see Mr. Knox.
So, just to be clear, today you might be a little nervous, but you knew that you were convicted of a crime. In fact, you were able to tell Mr. Butts that, right?
Yes, I know what you're talking about. Yes, I understand what you're talking about now.
He was like this little lost kid, and you wanted to tell him where the bus stop's down the street or something like that. And that has something to do with his syntax. His language suggests to me someone who's going through life looking at reality through a black screen, and there's this tiny little pinhole in it. And all he can see through that tiny little pinhole is like a frozen frame, a snapshot. And he looks at one thing, and then he looks at another thing, and then he looks at another thing. And this is what his syntax is telling me. Now, he has to know he has a gun. And I'm having trouble with the word gun, but I'm really having trouble with that word to know.
But if he was capable, had enough knowledge to find a sporting goods store, to buy a weapon, to take it home, admitted he had it at home, and through the questions that were asked of him by the various police officers, sheriff, etc., volunteered that information, that he had it at home, that he did indeed have a gun, and that he had it at home. I believe he knew he had it. Go ahead.
I'd like to expound upon yours too about knowing that he had the gun. He may have known that, but I'd like to take that to the first point, that he was a known felon. It was known by maybe everybody that dealt with him, except him. And before the point he was charged, if you could go back in time, which again is maybe speculation here or whatever, so take it for what it's worth, and you could ask him, Mr. Reed, are you a felon? What would his answer be? And he would probably come back and say, what is a felon? I don't even know if you're talking about a bird or a point in law or what.
I wonder if we could find room in the law for those of us that feel that we need to follow the letter of the law, that perhaps he didn't, in the full sense of the word, know he was a felon, and didn't, in the full sense of the word, know that he possessed a firearm. Because he did show a lot of confusion on that witness stand, and as someone had said, at one time he had said he was not a felon, and at another time he said that he was a felon. He becomes confused easily.
I think we're getting too much in the psychology of him, and none of us here are trained for that. We're getting too much into the psychology aspect of this, of what, oh, okay. Oh, then you're the one that should be leading all of this. Because who are we then to judge that he was thinking this and he was thinking that and he didn't know this and he didn't know that?
Well, believe me,
You should be the expert.
even among psychologists, this is going to be a very debatable issue. I think we're talking about what level did he know it, and we need to decide what that is.
The hang-up seems to be in the word, did he know? He knew he had to register it, which he did. He knew he had to have a permit for it. So on one hand, you're saying, well, he knew this and he knew that, but he didn't know he had the gun. I mean, I think you're kind of splitting up the nose on it. You're willing to say he knows this, but he doesn't know that, and
I don't think we should decide his intent or his what he understood and what he couldn't understand and everything. I think that's although some of you are experts in your respective fields, and I can appreciate that, but I think that's beyond our scope.
But I think we have more capabilities than to say 1, 2, 3. These are met on a very simple level, cut and dried, guilty. I don't think that we as jurors, that is necessarily our role. We are here to do more than that. I'm trying to decide in my own mind has justice been done here? I don't care what the law says. Has justice been done? And in my mind, I'm still trying to decide that. And that's my basic point. That's what we're here to do. It's not to just say the law says this, the judge says that, but I don't think that's what he means. And you can say I'm speculating, but I think there's a purpose for us beyond just saying whether he met the criteria or not.
Why don't we tear off a little piece of paper, write down a decision one way or another, think about it for a few minutes and write down whether you think he's guilty or not guilty. You can open them and, fold them in half, whatever. You can open them and I'll keep score here, and then we'll know where we stand and we'll argue it from there. One says guilty. Not guilty. Oh. Guilty. Not guilty.
The jury's first ballot comes 1 hour, 4 minutes into the deliberations. The count, 3 votes guilty, 9 not guilty.
Not guilty.
But one quickly reconsiders.
Like I said, I feel I'm on shaky ground here. And I'm willing to go with the majority because I'm not strong on my stance. So this is the one time I need help.
Okay, there's a couple things I want to say. I look at the defendant and I think, is he a threat to society? And if what we decide here, if we decide if he's guilty, is that just? And if he is dangerous to society, why would the detective allow him to bring the gun in, transport it on a public bus, and ask him and request for him to bring it down to his office if he felt that he was a dangerous felon?
I must admit that puzzled me too.
I don't think that's a question if he's a danger to anyone.
I'm having a lot of trouble with that larger frame, too. I'm starting to ask some of these bigger questions about where is justice, who is being served, even why was this case brought? Okay, I'm having a lot of trouble with that.
I agree with you.
But in a sense, let's not divorce the two. I mean, I can see this man who is, in some part of his mind, he's thinking, I want to be useful, I want to be productive, I want to have a social role, I want to be a contributing person, I want to do the right thing. Damn it, I want to be somebody. And all of a sudden, detective. And that becomes something, if I am a detective, I can be somebody. Okay, so what does he do? He sets out, what are the conditions or qualifications or requirements for becoming a detective? Lo and behold, one of them is having a gun. So in this particular case, gun means qualification for becoming detective, and the whole thing is encircled by magazine article. So gun is something that's being imposed by a piece of fiction or an article, and,
I can understand a little bit now what you're saying. Was gun a picture on that page, or was gun something that you physically used to fire around?
But the book didn't tell him go to Smears on 7102 West Capitol Drive and buy one. He knew right where to go. He knew right what he was going for.
He had to look at the paper, and for all we know, he had to see a picture in the paper, too.
Well, that's what I'm saying. He knew what to do.
Well, no, wait a minute.
He knew how to recognize
I
a
understand
picture.
this point. There might be just a picture association between a picture in the newspaper or phone book or whatever it was that he looked up Spears.
On the basis of the testimony, I have to disagree. I mean, maybe, correct me, but my recollection is two things. That the global detective course, I'd like to find a deep pit to throw that into. I know, it gets pathetic after it's comic. Okay, I think the global detective course, it gave its warnings, but I think one of the things they said was, you got to get your requirements for being a detective, and I think the global detective course said one of the requirements is a gun.
Leroy, why'd you get the gun?
The gun is a part of the course.
Where in the course does it say that you need to have a gun?
It's the application. It's a section there which shows where guns is, where you purchase guns.
Was the gun that you bought the only gun that you looked at?
Yes.
You didn't look at any other
Oh, well,
guns?
I looked at other guns, too.
What other kinds of guns?
It was an old antique gun.
Did you like that one?
Yes, it was pretty sharp.
Why did you like it?
It was pretty nice.
Did you buy it?
No,
Why not?
I had no cause to.
He goes to the antique gun. Why? Because it looks cool. This thing looks neat. Hey, it's, you know, it's like a...
Sharp.
Sorry?
Sharp.
He said it was sharp.
Yeah.
I mean, imagine flashing this to the girls or the guys or something like that. I mean, so...
That's not Leroy, no.
All right. Did you find out something about me with that comment? In any case, but it corroborates the notion that he's purchasing a visual image, not what you and I are going to do with gun.
He knew enough to go from his global course to go to the newspaper, to go to the store.
Or to go
It's
to
not
the
like
safety building to
it's not
study
like I went to
something for that
global
matter.
and they gave it to me.
Something
He
else.
knew enough to make the steps along the way. He knew to get one. He knew how to look one up and find it. He knew where to go and get it.
I'll say something right here. I don't think he knew he was breaking the law because he wouldn't have bought the gun in the store. He would have bought it off the street somewhere. Okay, that's all I wanted to add. Y'all can go ahead with whatever you were saying.
I don't know how long we're going to stay on that first point. The thing that I'd like to address is, did he know he was a felon with the possession of a gun? In my mind, I have a huge reasonable doubt that he knew he was a felon because he was very cooperative. He was the one, I mean, he wasn't trying to hide. Number one thing, he wanted to do everything that was right. And he was willing, he was the one that was willing to bring his gun. He offered everything.
Isn't even important in deciding our case because it's agreed upon by all parties that he was a felon. They're not arguing whether he knew it or not. They're arguing whether he was, and that's the element. The element isn't that he realized he was a felon or not. The third element on there states that he was or wasn't, and it was agreed that he was. So our basic argument has to be on the first 2 points.
I think it's the collective, we the people, that has to be considered along with the letter of the law.
After 2 hours of discussion, the position of each juror is clear. The majority tries to persuade the two holdouts that justice requires a vote to acquit. The foreman calls for a second ballot.
Not guilty. Not guilty.
One person still feels guilty.
I feel that we're going much too far into his psychological state that most of us are not qualified to do. We're picking apart words out of this, words out of that. I could come down and put something down on his table and say this is orange, and I feel some of the people are going to tell me, no, it isn't. It's a mixture of red and yellow. Who's right? I think we're going way too deep into his psychological thoughts. We're guessing at what he was thinking. We're guessing at what he knew. We're guessing at what he didn't know.
No, I changed my mind. I have something to say. I came into this room saying the same thing. Yes, the 3 points were met on face value, and he's guilty. And now those first 2 points, you could define them, it says that he had to know that he possessed a gun. He might have knew he possessed a piece of his course. And when you brought that up, and it made me think, and maybe he just was simply following instructions, had no relationship like you or I or anybody else does in this room between a gun and bang bang. I'm sure at his age he's watched plenty of TV, being whatever. You see detective movies on shows on TV, and every detective has a gun. His detective book, he's now going to be a detective. I'm going to be a stand-up citizen and be a detective. And the course says something about a gun. He's going to do everything he can to do it right. And did he really know what he was doing, or the consequences? Did he know that a gun was purchased, or did he purchase an item of his course? So that's my reason for changing my mind.
It appears to me that your decision that this man is guilty is very important and complete in your mind. And I'd share more of that with us, if you will.
I can't I don't have the education and the training to put myself into your class as far as being able to understand the human mind and how it works and what people think. And I don't think that's why we're here. It sounds very cold and simplistic to look at 3 reasons and say, yes, they meant this, this, and this. The whole case seems like it doesn't belong here, first off.
Could I just
But
one very brief question? Do you think there's ever a case where there could be an exception made? Do you think there is ever a case where exceptions can be made?
Sure.
This man, in all goodwill, brought this gun in, gave it to the police. They asked him to, he did it. I don't think he understood that he was a felon. I don't think he understood the significance of a gun. He didn't understand so many things, but when somebody told him, this is wrong, please bring this in, he did it right away. I don't think that there are grounds to convict this man on for his good intentions. I mean, there's got to be exceptions somewhere, and I, deep inside, believe there's an exception in this case.
You're saying that he didn't maybe realize that he owned a gun. Well, you're saying he knew enough that he was going to take the course, he knew enough he wanted a badge, he knew enough this, and he knew enough that, he knew to go to the sheriff's department, he knew enough to get the permit, he knew enough to register, but also he didn't know enough that he was owning a gun. You're taking things that favor you to say he knew this, but when it's something that you disagree with, he didn't know that. And he really couldn't logic this, and he couldn't logic that. And I don't think it's up to us to determine what his mind is working on.
I think this is a good law. And I don't want to say or do anything that suggests that I don't take that law seriously. So, I mean, I want to do my civic duty. I've got a lot of other things to do. I come down to the courthouse, and the DA gives me this. And in spite of this awesome room and these very serious people, and in spite of their lovely dog and pony show with the legal rigmarole, I'm sort of sitting to myself thinking, this is Mickey Mouse. I mean, I really don't feel that this is a justified expenditure of my time and attention as a juror. And we were asking the question, well, what about, the larger issues? What about justice? And justice is one of the things we're expected to be meeting out in this case. What about sending a message? And I'm thinking of a message I'd like to send the DA's office. Believe me, I would love to send them a message, and the message would be, damn it to hell, I'm afraid to walk to my car. In the parking lot, I've got, women students who are being mugged, who are being beaten, who are being raped. The same thing is happening to my male students. They're being mugged. And you give me Leroy. And I feel like saying, guys, you're doing a hell of a job. I mean, he walks into the police department. He gives them, the incriminating evidence. He gives them a confession. He gives them, the gun. He gives them everything. I mean, I'm sitting there. I'm a young DA, and I'm a little hungry. And I look at this guy, Leroy, and I think, maybe I got me an easy kill here.
What we're saying is this trial shouldn't even have been brought about, which...
Yeah.
Right.
I believe that. I think that's...
I think probably 12 of us agree on that.
Yeah, I don't want to send a message over to the DA's office, sort of patting him on top of the head and say, bring me some jaywalkers next time. We'll really get them.
Really, Leroy Reed has had enough punishment, if you will, for what he did that was so wrong. And how long do we beat this thing?
What's going to happen
Between his arrest and between his days in court now, an awful lot must have happened to it. It's like, okay, so now he knows not to do that again.
Can he comprehend that?
He can.
You come in with a not guilty,
I think.
and Leroy's going to be out on the street, which he should be because he's not a harm to anyone. But what help is he going to get? What message did you give Leroy? He's probably not even going to know what day it is tomorrow.
The message we gave Leroy is that justice can be had.
Can you find doubt in your mind that these three
That he
criteria
knew he possessed a
apply?
firearm.
I don't find doubt with that. I think with all the things that Leroy has done, he knew, you say that he was following instructions. That's making him look, I don't know how, yeah, I don't want to call him stupid, but it makes him look like a dog. Leroy, do this. Leroy, do that. Leroy, you don't know anything. And I don't think Leroy was like that. Leroy knew enough to take a bus here. He could do this. He could do that. Many things on his own that he did not have to be told what to do.
I know that in terms of the literal years, this man's what, 42?
Yes.
But you step inside that head, and you're inside the head of a 6 or 7-year-old.
Right.
Now, I don't know how you feel about watching a cognitive 7-year-old get caught up in this legal mechanism and just watch with this exquisitely agonizing thoroughness as it sort of puts him through the entire mill. That's why I said earlier, I mean, as this thing went on, I found myself wincing. It was like watching a grown man beat a child, and I'm supposed to be sitting there applauding for the DA. And something in my guts is saying, this is grotesque. I mean, the guy comes in, he supplies everything, and then we catch him in this mechanism. It's like something out of Kafka.
I think that there's a lot of consensus that this whole thing was grotesque and unreasonable. I think you agree to that too. But your difficulty, if I read you right, is in applying this law and, in following the law on a very concrete level.
I look at it very basic. And I will not hold out to hold up 11 people that are very strong in their feelings. I will change and vote along with you to make it a unanimous vote, but I will never feel right about it. I feel it was pushed by the jury on psychological and other feelings that I do not agree with, but I will go along with the unanimous verdict.
Is there something we could talk about?
Well, we can vote right now.
No?
We can vote right now.
No?
No, we're not ready yet. Yeah, I
Y'all want to make me feel better? Okay, fine.
Wait a minute. This is important.
I probably look at it too basic, 1, 2, 3. But I just, when you get to the reasonable doubt, I don't feel that there is. I think because of this trial, if there's any way that Leroy gets any kind of help, I'll feel good about it.
I found myself feeling real down last night. I was aware of the weight that's on each one of us as a juror. And I thought, hey, this guy's guilty. Is there some way out of him being adjudged guilty by us? Could I live with my writing guilty for this particular person? Boy, I mashed around with that for a while, and I said, if there's any justice really, it's in drawing attention to this man's personal situation and limitations. Getting rid of the firearm is okay too. But judging him not guilty, then I can believe in jury. I mean, that's where I find myself.
Let's say we take a vote. Let's say we take a vote.
Do you feel better, worse? I think we have to really consider how you feel.
Good about
No. But he said that he would vote guilty even though he would feel bad and wouldn't, and I don't feel good about that. I have a hard time thinking that this man should go through his life feeling I'm guilty just to get a.
Do you think that he was able to understand that he was able to keep these two thoughts and link them together at the same time when he bought the firearm, that he was a convicted felon and that he was not supposed to own a firearm? Do you think he had the mental capacity to understand the ramifications of that?
I think he knows that he was a felon. And I think he knew that he bought the firearm. the possibility of the two together would be the weakest point for me.
Okay. I think everyone is having a bit of a problem with that.
Let's say we take a vote on it, rather than beat a dead horse here. Not guilty.
After 2 hours and 28 minutes, the jurors have found their own path to a verdict. Their decision combines reasonable doubt with their feeling that the law should not be enforced in this case.
I still think it's a strength of the jury system, because if you do have that, if you just have legal professionals, no matter what level they're at, deciding this case, I think it would have come up with a different verdict. And I wouldn't have felt right about that.
The power of a jury to go its own way is inherent in our legal system. Some fear that this power can be abused and work against justice. This may happen if jurors ignore evidence and allow racial or class prejudice to determine their verdicts. But so-called runaway juries have played an important role in our history. They defied the fugitive slave laws and later helped overturn prohibition.
But our game isn't done when we leave this.
Today, in some political sanctuary and marijuana cases, defense attorneys are asking jurors to ignore the letter of the law and follow their conscience. To do so is not easy, as this jury discovered.
We're going to go outside that door, and but you can bet on two things. I mean, in the eyes of the defense counsel, we are going to be geniuses, saints, roll out the red carpet. In the eyes of the DA, we're going to be a bunch of dupes, lackeys. I mean, sentimental, bleeding heart, whatever. So you're not delivered from the ambiguity. I mean, he really was right. You're standing there. You've got a lot of things going on. You're not really sure. You've got to make a decision. And it's hard. And you've got to live with it.
All rise.
Every year, some 5 million Americans serve as jurors and play a vital role in our system of government. At a time when there seems to be doubt about the individual's ability to influence the law, the verdicts of ordinary citizens are vital indicators of community values.
Sir, has the jury reached a verdict? Yes, it has. Could you hand the verdict form to the bench?
In the case of Leroy Reed, an independent-minded jury helped a man who faced long odds find justice.
Case number L0855, State of Wisconsin, plaintiff versus Leroy Reed, defendant. We, the jury, find the defendant, Leroy Reed, not guilty. Signed by the foreman, James R. Pepper.
All right. You, ladies and gentlemen, as representatives of the community, bringing with you the conscience of the community into this courthouse, has spoken. And in a very real sense, folks, you are the last bastion, the last vestige of citizen control over a most important governmental function. And in this country, unlike countries all over the world that we read about in the paper or see on television, you cannot be picked up off of the street and locked away without having a court of law and a jury of citizens pass on a charge. That is the keystone of our freedoms, and in my view, is the reason we are a free people. And I'd like to thank you so very much. Court's adjourned.
The power of a jury to rise above the law is an established principle in our legal system, and juries are always challenging and changing the course of the law. But there are also some changes happening to our jury system. In civil cases, large jury awards and liability suits have prompted those affected, like doctors, manufacturers, and most importantly, insurance companies, to lobby for laws to limit the kinds of cases juries can hear and the amount of money they can award for damages. In criminal cases like Leroy Reed's, however, the right to a jury trial is secure, although some states have decided to use 6-person juries and have dropped the requirement for a unanimous verdict. As for Leroy Reed, although the odds seemed against him, because of a jury, he found justice. Please join us again for Frontline. I'm Judy Woodruff. Good night.
If you're hurt in an operating room, should you take your case to the courtroom?
You saw this autopsy. You're a neurologist.
The only protection that the patients have is the malpractice lawyer.
Patients are aware of the malpractice crisis, and patients will ask you straight off, are you doing this because you're concerned about my suing you? If something goes wrong, I'm screwed.
Should you sue the doctor? Next time on Frontline.
For a transcript of this program, please send $4 to Frontline, Box 322, Boston, Massachusetts, 02134. Frontline is produced for the Documentary Consortium by WGBH, Boston, which is solely responsible for its content. Funding for Frontline was provided by this station and other public television stations nationwide, and by the Corporation for Public Broadcasting.
Schools, colleges, and other organizations interested in purchasing or renting video cassettes of this program may call 800-424-7963 or write PBS Video, Post Office Box 8092, Washington, D.C. 20024.